top of, they're top of their field, and they should be top of mind for you guys as well. So my name is Patrick McQueen. I'm a real estate attorney here in Arizona. Our firm only handles real estate matters, whether it's commercial or residential. Chances are we've handled the situation in the past. The things that are keeping me busy, I usually give an update on kind of what's going on in the real estate legal world right now. A couple of things. First is the Kalway case, Kalway. We talked about this on prior webinars for WeServe. There's a lot out there on this case, but this is the case that changed HOAs here in Arizona. It came down at the end of April by the Arizona Supreme Court. And basically it said, look, an HOA cannot go around and pass amendments to their CC&Rs unless there's 100% vote, or unless the thing that you're amending, the amendment to the CC&Rs, actually relates back to something that's in the original set of CC&Rs. So this has a huge effect on short-term rentals, on parking, on your ability to do certain things with your home. And so that Kalway case, Kalway, if you need a copy of it, let me know. I'll get it to you so that you can take a look at it. But in particular, our clients who are into the short-term rentals and agents who help their clients buy short-term rentals really need to take a look at this case to determine whether they now can buy in HOAs that were previously adverse to short-term rentals. So that's a big case. We also have new wholesaling laws. So Governor Ducey came out sometime in May and changed the way in which we can do wholesaling here in Arizona. We now have to make certain disclosures to the people we're buying from and to the person we're assigning contracts to. If you need that sort of disclosure language that is now required by statute, you're more than welcome to have it. I'll get it for you. Shoot me an email after this class. I'll put my contact information in the chat so that you have that. And then the third thing that we've been working on is, as the economy maybe softens a little bit, people are asking about the enforcement of contracts, the enforcement of remedies. What are my rights under this contract? Whether it's a residential contract, whether it's a commercial contract, what can I do to put this person in breach? What can I do once I know that this person is in breach? What are my remedies? So, we talked about this at the last WeServe commercial webinar. I would encourage you to take a look at that, because there's a whole host of things you can do as a buyer or a seller to put the other parties in breach and to enforce your rights and remedies, whether it's on a purchase and sale agreement, whether it's in loan documents, whether it's in a lease agreement. Very important to take a look at the contract and consider taking a look at that prior video that we did about a month ago. Okay. The fourth issue, and this is an issue that we see all the time. This is probably one of the biggest litigated situations that I've dealt with over the my 20-year career, probably approaching 250 different cases involving bad fix and flips. Okay. So over the last 20 years, I've seen fix and flips go sideways. We've represented the buyers, we've represented the sellers, we've represented the agents. Agents have a bigger target on their back, whether they're actually the ones doing the fixing and flipping, or they're just helping a buyer or a seller. You've got a target on your back. And so what we're going to do is talk about ways to keep you out of trouble. Okay. So again, one of the biggest issues that I've seen over the last 20 years are bad fix and flips. Either the person doesn't know what they're doing, they get themselves into a world of hurt, they fail to disclose, whatever that may be. We're going to talk about ways that you as agents can avoid legal problems when it comes to fixing and flipping. Now, I'll tell you, we usually see more fix and flip kind of issues or non-disclosure kind of issues when it rains, like it has been. I don't know if anybody else was woken up last night by the rains, but we had some good monsoon rains last night. And those usually lead to more fix and flip claims against somebody who did a fix and flip because they didn't put up the adequate wall, because they didn't, disclose certain issues, and because they allowed the drainage to get worse, or whatever it may be. Fix and flip issues usually come out more so when we have flooding and when we have rains. Okay, whether there's an HVAC issue, whether it's whatever it is, they seem to come out now. Okay. And so what we're going to talk about today, are the reasons why you have disclosure obligations, or to discuss your disclosure obligations when it comes to fixing and flipping. Remind you of those obligations. We sort of tell you all of the horrible things that can happen to you We'll give you some examples of things to be mindful of in your day-to-day practice, and then I'll end with some tips on protecting yourselves. If you're doing the fixing and flipping, if your client's doing the fixing and flipping, there are some things that you can do to make sure that you're doing everything above board and making sure you're not getting into trouble. So why are adequate disclosures so important, particularly for real estate agents when there is a fix and flip involved, when there's somebody either doing it or you're doing it yourself? Well, number one, you could run into E&O issues, errors and omissions, okay? So you as a real estate agent are probably covered under an E&O policy, an errors and omissions insurance policy. Just like if you get in a car accident, you've got to pay a deductible. Well, if you get a demand that you've done something wrong, that you were involved in a bad fix and flip in some fashion, you're going to get a claim asserted against you, okay? Or you may get a claim asserted against you, whether it comes through a demand letter or an actual lawsuit. You've now become aware that something went wrong with this transaction. And now you've got to tender this letter and this claim over to your E&O carrier. Just like in a car accident, you've got to tender your insurance coverage over to your carrier to defend you. Same thing here. Your E&O company, your E&O coverage company, your E&O insurer will tender this, will accept this claim and defend you. Well, if you were involved in such a bad fix and flip because you didn't make any disclosures, because somebody got hurt, etc., you may not have E&O coverage. Okay, that's a potentially scary proposition. Okay, so one of the reasons that we want to make sure we're doing all of this stuff very above board in fix and flip scenarios is because you want to make sure that if something does go wrong, that it's an innocent mistake, that it was something that you didn't foresee, that it's something that E&O, errors and omissions, actually covers. Okay, because if it's not covered by E&O, you're on your own. You've got to pay a fraud-based judgment. You've got to pay this judgment on your own. And so some people say, well, big deal, no big deal, I'll pay it, or I'll just file bankruptcy. Well, you usually can't file bankruptcy. Bankruptcy does not protect you in a bad fix and flip situation if there was fraud involved. And so you got to be very, very careful about the disclosures, about avoiding fraud. And so the number one reason that adequate disclosures are so important in fix and flips, and one of the biggest legal issues I see, are these E&O issues. Errors and omissions might not cover you if you're doing bad fix and flips, if you're doing something that's not above board, okay? Second reason is to avoid getting into trouble doing a fix and flip. And second reason to consider taking some of this advice that I'm going to provide is that you have to report an adverse judgment to the Arizona Department of Real Estate. So even if it's your own private deal, the fact that you're a real estate agent requires that you provide this information to the ADRE if you get in trouble, okay? Even if it has nothing to do with even if you're not acting in a capacity as a real estate agent in the deal, you still have reporting obligations to the ADRE, to the Arizona Department of Real Estate, if you get yourself into trouble. And so nobody wants a slap on the wrist or a penalty from the ADRE. The third reason that you may want to consider taking this advice seriously, or to do everything above board as an agent involved in a fix and flip, is because of the risk of punitive damages, okay? So punitive damages are damages that are intended to penalize somebody, to make an example of somebody. And ordinarily, for the first 17 years of my career, I've been doing this 20 years, for the first 17 years of my career, I never saw a situation involving a fix and flip and punitive damages. Well, over the last year, I've seen two situations involving fix and flips and the imposition of punitive damages. So let's say that somebody in the transaction failed to disclose that there was black mold at a property that they fixed and flipped, and they just painted over it or stuccoed over it, didn't disclose it, didn't do anything about it, and somebody now gets sick because of the black mold. And it comes out that you knew about it or somebody knew about it. Well, what will happen is a judge or a jury will have the opportunity to impose damages against you or against the party that's failed to disclose this, to fix the issue. So those are sort of these actual damages. What is it going to take to fix my house, to get the new drywall, to get a clean bill of health on the home? Well, then they also may impose what are called punitive damages, damages intended to penalize you. And so I've seen damages intended to penalize people, or punitive damages, come up twice in the last year or so for failing to disclose in connection with a fix and flip. Now, again, I don't know if that's a trend. I don't know if that's happening more than what I've seen, but I've seen it twice in the last year or so, and I'd never seen it in the first 17 years. And so you want to make sure that everything is above board, whether you're representing the seller, or whether you're representing the buyer. You want to make sure that you're doing your due diligence and doing making adequate disclosures. And so those are really the three reasons that this stuff is kind of important that we're talking about, okay? And for punitive damages, you're not going to get E&O coverage for that either. So if your E&O insurer realizes that there's a punitive damages issue here, they're not going to cover you, and that's something you're going to have to come up with out of your own pocket. So that's a scary proposition. So in those two scenarios that I've seen punitive damages in bad fix and flip scenarios, one was a failure to disclose mold. So there was a crack in some walls, there was mold in the crack that proliferated throughout the house. People painted and stuccoed over the cracks and the mold, and so there was no disclosure about it, so somebody gets sick. The other was the failure to disclose the lack of water source to this particular property. So a neighbor had cut off well access to this particular home while these folks are doing the fix and flip. They knew about this, they failed to disclose it, sold this property to this buyer. Buyer has no water now, and so the buyer in this situation was able to sue for punitive damages and won punitive damages. And so those are real reasons that we're talking about this stuff today, because I don't want any of this stuff to happen to you. I'd rather have you guys as clients in some other capacity, or real estate agents in some other capacity, than defending you. And so that's why we're talking about this today. Now let's talk about the types of legal claims that we will typically see in a bad fix and flip situation. Okay, the first is common law fraud. Okay, so what we're talking about are the 5 or 6 ways in which somebody could sue an agent, somebody could sue a seller for failing to disclose, for having a bad fix and flip. The first is common law fraud. Common law fraud involves a situation in which the flipper outwardly lies. They just say, this house has never had mold, when in fact they knew that they painted over mold, when in fact that they had a mold report that said that there was active mold. That is common law fraud. That is an outward statement that's false. We see that in fix and flips. Okay, people either don't understand Arizona law, they think that they can lie about it. We're going to talk about some other misconceptions or misperceptions about disclosures and fix and flips in a second, but the first type of claim is common law fraud. It's an outward statement that is straight up false. Okay, we also have fraudulent misrepresentation. That's kind of the stepbrother or stepsister of common law fraud. Again, common law fraud is the outward statement. Fraudulent misrepresentation is the failure to disclose when an opportunity arises. It's sort of fraud by omission. So if you're standing at an open house and you know that this person just did a fix and flip, and somebody comes in and says, well, you know, I heard they had mold and I'm really glad they got rid of it because now this is such a lovely home, I might consider buying it. When you know that there's a mold report in the kitchen drawer that says there's active mold. Okay, so you had the opportunity there to step up and you just kind of didn't do anything. You weren't outwardly lying, but you didn't step up with the knowledge that you have based on what you were told or based on the information that you found. Okay, so there's common law fraud, which is the outward statement. And then there's fraudulent misrepresentation, which is the failure to state when you have an opportunity to state something. Okay. The third type of fraud claim that we see in fix and flips, in bad fix and flips, involves what's called consumer fraud. Consumer fraud usually involves advertising. And so if you're using words that are absolutes, like everything was redone, everything was remodeled, brand new roof, brand new pipes, brand new HVAC, when in fact only parts of those things were taken care of, were done, well, that's false advertising. That's not necessarily correct. And so you can be hit with a claim for consumer fraud if your advertising materials are incorrect. And so we'll talk about some words that you can use that are a little bit better than these absolute words that can get people into trouble. Okay, so we have common law fraud, which is the outward statement. We have fraudulent misrepresentation, which is the failure to state anything. We have consumer fraud, which is basically fraud in your advertising. And then we have negligence or negligent misrepresentation. And this is the type of claim, negligence, that E&O actually protects you against. Okay, it's an innocent mistake. You just made a mistake. You put in there that there was an extra bathroom when there in fact wasn't. You put in there that there was extra square footage when there in fact wasn't. You put in there that the casita was fully permitted when it wasn't. You put in there that you thought one set of facts that existed, but it actually didn't. It was an innocent mistake. And so that's another type of claim you may see in these situations being brought up. Again, we're going to talk about ways to get rid of all these claims and make it so this stuff doesn't happen, so you don't have to worry about it. But I want you to know this is sort of the anatomy of what it is we see on a fairly regular basis involving bad fix and flips. Okay, so again, we have common law fraud, fraudulent misrepresentation, consumer fraud, negligence, which is the goof up, and then we have a breach of contract claims. So in each real estate contract, there's a statement, I think it's in section 7, that says something to the effect of seller has disclosed everything that they know about this property, including X, Y, and Z, or something to that effect. I don't have it in front of me. But if that is breached, if they haven't actually disclosed everything that they know about this property, then you can sue for breach of warranty or breach of contract. Okay, so those are largely the claims that we see. We also see the violation of contractor statutes. And what I'm getting at is the situation involving unlicensed contractors. And so in Arizona, you are in violation of a Registrar of Contractors statute, or the Registrar of Contractors statutes, requiring that the person doing the work be licensed if the cost to do that work is over $1,000, or if what we're talking about here are major system types of things. If we're talking about paint, nobody needs to be licensed to do that, although it's not a bad idea. If we're talking about structural issues, if we're talking about electrical issues, if we're talking about pool issues, then the person needs to be licensed to do the fix and flip work for you. There are a couple of exceptions to that. Again, it's the handyman exception. So if the work in total is $1,000 or less, you don't need to have a license to do that. Or if you're doing the work for yourself because you intend to live in this property, which is completely opposite of what a fix and flip is. Fix and flip involves you wanting to get this property gone as quickly as possible, then that exception applies as well. So you're not in violation of those contractor statutes. But the contractor statutes actually come with jail time. So there's financial penalties, there's lawsuit potential, and then they're also misdemeanors. And so you want to make sure that you are dealing with licensed contractors, or to do this fix and flip work, or you're doing the work for yourself, or you fit into this handyman exception where we're just sort of doing paint work, touch up, cosmetic, handyman work. Okay, so those are the statutes. Yeah, so Jay asked the question, does a person laying flooring or doing tile work need to be licensed? Probably not. The answer to that is probably not. Unless they're doing something that is, where they're having to knock out a wall to put tile in, or something, involving that. If they're just laying tile, I don't think they need to be licensed for just for that. So good question there. So what we're talking about in the licensing stuff is the stuff that can get people hurt if you're not licensed, if you're not sure of what you're doing, if you don't have a bond, if you don't have insurance for what you're doing. Okay. So the question comes up, what is the statute of limitations for these types of claims? People are concerned, like, oh gosh, I had this deal and what's the latest point at which I need to continue worrying? Well, the statute of limitations for all those claims ranges from 1 year to 6 years. Statute of limitations refers to how long somebody can come after you for one of those claims, for a bad fix and flip. And the answer depends on the type of claim being asserted. Negligence is the most common, and that's a 2-year statute of limitations. A breach of contract claim is a 6-year statute of limitations. And so those are the sort of legal things that we see come up all the time. Those are the types of claims that we see. And so I wanted you to know at least those basics, because that is very common to what it is I see. Now, I want to go over some common misconceptions or misperceptions that we run into all the time. And one of the biggest one is, well, I'm doing this fix and flip, and the person who I'm selling to knows that they're buying the property as is, right? How many times have you heard that one? Well, I sold the property as is. The person's buying it from me as is. I didn't need to make a disclosure about the mold that I encountered. I didn't need to make a disclosure about the crack that underneath the tile that I didn't patch up. whatever it is. They bought it as is. It's their obligation to figure out if there's a problem. And the answer to that is wrong. The answer to that is no. The as is addendum just means that that person may or may not do repairs with respect to any particular item. Okay. There is still a 100% obligation to disclose what you know, what you encountered. Okay. So in a lot of times we see people coming from out of state and they want to do fix and flips here in Arizona, and they require that their buyers buy the property as is because they think that that somehow magically protects them. It does not. It actually puts a red flag in my mind saying, oh, I wonder what's really going on here. Why are they insisting that that this buyer buy as is when it's already in the contract? Okay, why are they highlighting this? So don't highlight that. Okay, so the as is does not relieve you of your obligation to disclose. It does not get you out of a fraud-based claim or misrepresentation claim. Same thing goes for the SPUDS waiver, the SPDS waiver, the seller property disclosure statement. A lot of times, particularly when people come in from out of state, they'll buy a property here in Arizona and they insist that that the buyer will buy as is and that they are not going to provide you with a SPUDS. Okay. And the thinking behind that is, well, I don't know anything. I never owned this property. I've only owned it for 6 months while I do this fix and flip. And therefore, I don't know enough to make adequate disclosures pursuant to this SPUDS, right? And I've got this huge SPUDS that can be filled out, but I'm not going to fill any of it out. And the answer to that is also wrong. And so that puts up a double red flag. So anytime I see somebody or I'm advising a flipper, don't require that people, buy as is. It's already in the contract. Don't require that people waive the right to receive your SPUDS, because again, what's the problem? If you don't know an answer, then that's perfectly fine. But why are you requiring that somebody not receive your SPUDS? You know something about the property. You know when you bought it. You know what you've done to it. You know more than probably anybody about the structural issues with respect to the home. So to me, don't highlight that. Provide a SPUDS, particularly in a market like we have now. Disclose. It's usually not harmful at all. Okay. The other common misconception or misperception that I run into are the contractual admonitions. So in your contract, in the SPUDS and in the buyer advisory, there's all sorts of stuff that basically says, hey, real estate agents don't know anything about the transaction. They don't do any due diligence, and you are contractually forbidden from suing your real estate agent or suing the agent involved in the transaction. And so, whenever I'm defending a real estate agent involved in a bad fix and flip, they always point to that, it's bold, it's black, it's 16-point font that basically says you can't sue a real estate agent. And I got news for you, they can be sued. And so those contractual admonitions are just there to maybe dissuade people from suing real estate agents, but those contractual admonitions do nothing. They don't. You can't hide behind contractual admonitions. You can't hide behind these contractual waivers. I've had judges sit in a CE class that I've taught about fix and flips, and what they've told me they will do is they will say, look, I don't know what this buyer understood with respect to the contract. Even though the buyer says that they've signed everything and understood everything and they had their own agent, I don't know what it is that they understand about what they're waiving, whether they understand that they're waiving their right to their SPUDS, whether understand what an as-is addendum is or a clause is, and whether they understand what they're waiving with respect to the contractual admonitions. I'm not going to make that choice. I'm going to let a jury decide whether they knew that. And so those contractual admonitions really are there to dissuade, but they don't get you out of trouble. Okay. The fourth sort of misconception or misperception that I see a lot are people that operate through a PLLC or they operate through an LLC. Well, the fact that you have an entity is great. And I think that everybody who is doing a fix and flip should have an LLC that they're doing the fix and flip from. I think you should have a separate LLC each time you do a different fix and flip. I also think as a real estate agent, you should have a PLLC because there's a number of tax benefits, potential tax benefits, and there's a little bit of potential in terms of asset protection there. But the mere fact that you're doing you have an LLC or a PLC does not protect you against fraud. So a lot of people think, well, I'm sheltered. I've got my personal assets over here. My business assets are owned by the LLC. Worst case scenario, they can only sue the business assets and they're held by a PLLC or an LLC. And the answer is, if you're setting up an LLC or a PLLC with the goal of trying to rip somebody off in a fix and flip, which is what I've seen. I mean, I see the worst of things. You guys, 99% of these are great, but I see the worst of things. You can't set those up for those purposes. And so the fact that you have an LLC or PLC does not provide you with any protection. Okay. The other thing that we run into, and our home inspector, who was a sponsor, is no longer on this call, but a lot of people say, well, it's the home inspector's fault. The home inspector was the last person to see the property for this buyer, and therefore all the blame should be placed on the home inspector. I shouldn't have any blame as the selling agent. I shouldn't have any blame as the fix and flipper or the seller. It's all on the home inspector. The home inspector was licensed. They had an opportunity to come in and check this stuff out. And unfortunately, for real estate agents, we have some very bad law as it pertains to home inspectors. So under Arizona law, if there's what's called a limitation of liability clause in the home inspection contract, and usually most of them have it, they'll say, if you find something that the home inspector has missed, worst case scenario, you can get your money back for the inspection. And those are enforceable. Okay. And so what that does is it puts the buyer's sights on real estate agents. They say, well, the real estate agent doesn't have a limitation liability clause. They have E&O. I'm going to go after the real estate agent as opposed to the home inspector, because max I can get from the home inspector is $600, the cost of the inspection. I'm now going to go after the real estate agent who has E&O coverage. Okay. And so a lot of real estate agents don't realize that. They say, we want you to go after the home inspector. Well, it doesn't make much sense to do that. Okay. And so to me, again, the common misconceptions are the as-is addendum protects me, or the as-is clause protects me. It does not. The SPUDS waiver protects me. It does not. Contractual admonitions save me. They do not. The fact that I have an LLC or PLLC might be helpful somewhat. They might create somewhat of an impediment, but they don't ultimately protect you if you're doing something totally incorrect. And then blaming the home inspector. The other question, or the other misconception, I guess is more of a question that I get when it comes to a lot of this stuff, or what about like Fannie Mae, or what about like the iBuyers who come in, they buy a property, they'll fix it up, they'll sell it for a profit, and then they specifically put in their contract, as a condition to you buying this property, we're selling it to you as is. We're selling it to you without a SPUDS. You specifically agree not to sue us. Those are very persuasive, but they're not enforceable. And so we see a lot of people who are frustrated because they bought from one of these iBuy companies that went in and did a bunch of fix and flip stuff to the property. They changed the property, and then the buyer comes in and says, well, I can't do anything because my contract says I can't. No, the answer is you absolutely can. The Arizona courts have allowed it over time and time again. It's just that OfferPad or whoever was doing this type of stuff was very persuasive in their documents in putting that information in there and thinking and convincing the buyer that they had no right to do any of this stuff, but you can. Okay, Arizona law is very clear on that. So again, we talked about the types of legal claims that we typically see: common law fraud, fraudulent misrepresentation, breach of contract, consumer fraud, negligence. We talked about the common misconceptions or misperceptions. One of the other things to as well is, sometimes people who are agents who are involved in an LLC that is doing the fixing and flipping say, well, I'm not the majority owner of the LLC, therefore I don't need to disclose my role in this transaction. Yes, you still do. That's a misconception that we see. But the main misconceptions are the as-is addendum and the SPUDS clause and the SPUDS waiver. Those just don't work. Okay. Now let's go through some tips. I'm going to give you some tips here for you as agents, for you as flippers, for you as buyers agents, helping somebody buy a flip, because I think all of these are very important. Okay. So if you are flipping, if you're the one doing the flipping, number one, always use an entity, always use an LLC. It gives you one extra layer of protection to protect your personal assets. They're very easy to set up. They're very inexpensive, usually $700 or $800, and a lot of protection. And a bank account is all you really need. Okay, so when you're flipping, always use an entity. When you're advertising your flip, okay, choose your words carefully. The words that get people into trouble are completely, as in completely remodeled, completely put in a new roof, whatever it is, completely, entirely, totally. Okay, those words are words to avoid when you're doing a flip. Okay, third, a bit of advice is the spuds is your friend. Okay, disclose everything, particularly in a market like we still somewhat of a buyer's market or somewhat of a seller's market. Disclose everything. Okay, disclose it even if it wasn't a seller's market. You've got to disclose. Use it as your friend, because again, if somebody comes up with some problem that they found and you've disclosed it in the spuds, the problem is no longer yours. It's not yours at all. So disclose everything. Use the spuds as your friend. Certainly avoid the third bit of advice is to avoid those myths that we discussed, like the spuds and the as is. And then if you're an agent and part of an LLC, you've got to disclose that you're an owner agent. You're involved in the transaction. So again, those are the sort of bits of advice that I recommend that you consider if you're doing the flipping. Again, always use an entity. When advertising, choose those words carefully. Third is to use the spuds as your friend. Avoid those myths we discussed, and always disclose your role in the transaction, particularly if you're an agent. Okay, so if you're buying a flip, okay, so that was the advice. If you're flipping, if you're buying a flip, number one, get an inspection. If you know it's a fix and flip, it doesn't hurt to get an inspection. I've seen so many people waive the inspections over the last year or two. I don't know why. Even if they're not going to do any fixes or work, after you've found something that you've discovered, get an inspection anyway. If you're buying a flip, number two is to request the claims history and request the spuds. It doesn't hurt. Request contractor information, receipts, warranties. And the reason you're doing that is because some of these warranties, the contractors have to provide by statute a warranty of 2 years. Okay, a lot of times they'll skimp on that. They'll try to provide one or no warranty at all. By law, under the Registrar of Contractors, they've got to provide a 2-year warranty for their work. And so you want to make sure you have these contracts to see what was done and to know who to contact if there's a problem. So if you're buying a flip, again, get an inspection, get maybe multiple, request the spuds, request the claims history reports, request contractor information, receipts, warranties. And then the other one is to confirm verbal representations via an email. Okay, so let's say that the seller is there and they're making all sorts of claims about the materials that they use and how complete they were with their work. Well, when you get back home, when you get back to your phone, when you get back to your computer, go back and say, it was great seeing you at the property. As we discussed, you mentioned X, Y, and Z. Let me please confirm that that's correct. So you're confirming what you heard via an email. Okay. Yeah, so Jared writes in the chat, which is perfect. I was involved in quite a few flips over the years. We very specifically disclosed everything we could think of, and it never kept a deal from being completed. Don't be afraid to disclose. Yeah, no, I 100% agree with Jared on that. That document protects you. Use it to your advantage. The only time I've ever seen a spuds ruin a deal, and it wasn't even the only times I've seen it a couple times, but the only time I've ever seen the spuds ruin a deal was when somebody disclosed scorpions. And it's like, dude, you're moving to the desert. What's the problem here? But I've seen it happen 2 or 3 times over the years, and it was just scorpions. And I'm like, really? So that's you usually will not lose a deal on a spuds. And frankly, if you do, you're likely to find another buyer pretty quickly. So to me, you got to use that document as your friend. Okay, now if you are an agent assisting a flipper or a buyer, right? Let's avoid putting stuff in writing or so much stuff in writing. Okay, I've represented agents over the years, and I tell this story all the time. I had this agent that I was representing, and he kept saying, Patrick, I've done nothing wrong. You got to trust me here. This is just crazy. This is just a witch hunt, whatever. And I believed him, and I had no reason to doubt him until the other side subpoenaed his email records. And the first email that they put to the top when they got his Google account or whatever it was, or Gmail account, was an email from him to his broker that says, "Oh, S word, I really messed this one up." And it was this explanation to his broker of all of the things that he failed to disclose in connection with this fix and flip. And I'm like, okay, dude, if you would have picked up the phone, maybe this would have been harder to figure out, but you just put it all out there and you admitted that you goofed this up. So first is to make sure you pick up the phone in certain instances. Certainly document and paper your file after you've figured out the issue, but in those situations, anything that you say to your broker, anything that you say to your client, anything that you say to your spouse, put in writing, text, email, whatever it is, that's fully discoverable. Okay, so this brings me to my second big bit of advice. If you're an agent assisting a flipper or a buyer, is use the attorney-client privilege to your advantage. Anything you say, again, to your broker, to your spouse, to another party, not privileged. Anything you say to me, if I'm working in connection with you as your attorney, is absolutely privileged. It cannot be discovered. I have a legal obligation to not disclose it because the goal there is to figure out a way to resolve the matter for you. So there are certain privileges that the law world has created, one of which is the attorney-client privilege. So use that one to your advantage. The third, obviously, is to choose your clients wisely. There are some shade ball folks out there, and they're looking for ways to protect themselves by using you to their advantage. So you want to choose your clients wisely. And certainly paper your file, as I mentioned. Paper your file. Hey, it was good seeing you at the property. This is what I told you. I told you to see a CPA. I told you to get an inspection. I strongly advise that you contact so-and-so for those services. So those are the tips for if you're flipping. Those are the tips for if you're buying a flip. And those are the tips that I have for you if you're an agent assisting a seller in connection with the flip, or a buyer in connection with buying a flip. That's a lot of stuff. That was 42 minutes worth. So we got about 3 minutes for questions. If anybody has any, will the recording of this be available? That's not a question that I can answer. Sorry. I think it will be. My suspicion is that WeServe has like a Google account or a YouTube account that you can download these from. If you need, I'll put my contact information in the chat as well. So just in case you have any questions of me that you forgot or need any other information, you can have that. I don't see any other questions though. So does anybody have anything? It's now time to get your free legal advice. You get what you pay for. Is a flipper responsible to include on their SPUDs information regarding flaws from the original SPUDs when they purchased? That's a fantastic question. I would say yeah, because they've now realized it. Yeah, I think that they are. That one comes up a lot, and so if you saw something in your original SPUDs, even if you disagree with it, for instance. I had a situation where somebody was selling a property. They disclosed the existence of termites. The subsequent buyer went in, got the termites checked, and there were no termites, and there was no evidence of termites. Somehow the seller either was wrong, or just didn't remember, or remembered incorrectly. Well, then the subsequent buyer turns around and says to their subsequent buyers, hey, when I purchased the property, the seller told me that they had termites. I determined during my period of ownership that I didn't see any, and therefore, you should look to see if you find any. So to me, that there's a soft way of doing that, where you're saying, look, yes, this was disclosed to me in the past, because that can be a piece of evidence. That prior SPUDs can be a piece of evidence. I didn't find a problem with this, or I believe I corrected this to the best of my ability, but this is something you may want to check out. So to me, I would probably disclose that. Yeah, I don't. So Jay writes, I don't think flippers typically understand their obligation. I would agree with you. The goal of a flipper is to get in, get out as quickly as possible. And, from a financial standpoint, that makes a lot of sense. You don't want to be stuck with a hard money loan if that's what you're doing. You don't want to be stuck with the property on the market, because if the market goes bad, whatever it is, you know, you want to get out of this. And so I don't think that they understand their obligations. But again, number one, it's a legal obligation, but number two, that disclosure protects them. And that's what I think a lot of people are, you know, they don't really appreciate that fact. It protects them. Well, Isabel, I don't have any other questions. And it's 9:45. So, you know, feel free to email me, guys, if you have anything. I'm happy to try to help you out there.